Welcome to Judica County. My name's Josh Whitaker. I'm your host. Today, Joseph Hamer's joining me. We're both attorneys with the law firm of McCullers, Whitaker, and Hamer, and we're here for Real Estate Closings 101. During these segments, we like to take a look at a real estate closing question that we get often. And so today we're going to talk about, as a buyer, your marital status and why that's important. Because it's very important when you're purchasing a house.
It is very important, and it's something that we get a lot of questions about. So I guess as a general baseline rule, I think the safest bet is if you're purchasing property, plan on your spouse attending. Even if they're not on the contract, even if they're just the safe bet is to plan on them attending.
We really run into a lot of, as a closing attorneys, we represent the buyer. And we run into a lot of buyers who have different situations, different kinds of, everybody's kind of got a different kind of marriage. They got things they're comfortable with, they're not comfortable with. So we see a lot of people who, husband and wives, want to be on title together. We see a lot of situations where only the wife or only the husband want to be on title by themselves. And so, you obviously have spouses that are estranged. And so you kind of just have to look at each scenario. But I think an overarching concept is, if you're getting a mortgage, I guess we should say, if you're paying cash for your house, you can do whatever you want to.
Sure.
Right? If you're paying cash for your house, you can have your spouse on title, your spouse not on title. It's really your call. But if you're getting a mortgage, your lender is going to be very concerned about their lien and how that attaches.
And that's a good point. So again, if you're getting a mortgage, plan on your spouse attending. Now, saying that, North Carolina does have a narrow exception to that rule. So we do, again, see a lot of situations where, whether it be estrangement, whether it be you're separated, but you haven't actually divorced your spouse, whether you're just separated geographically, whatever the reason may be, North Carolina actually does have a narrow exception that will allow for one spouse to sign when a mortgage is involved. And it's a fairly narrow exception. And basically, long story short, what it requires is you, as the signing party, have to be the only person on the contract on really anything. Mm-hmm. Your spouse's name can't appear anywhere, so your spouse isn't going to be on title in that situation. And it also has to be what's called a purchase money deed of trust, which means essentially you are taking out this mortgage and you're signing this deed of trust in the connection with the purchase of a new property. So it can't be a refinance. If you're refinancing, your spouse is 100% going to have to be there unless you've got a free trade or a premarital agreement that's recorded, separation agreement that's recorded, something along those lines.
And we should say we should add, so that's the purchase money exception. So so if I'm going to buy a house, I don't want my wife's name on title. I'm going to be, like you said, I'm going to be the only one on the contract. I'm going to be the only borrower. I'm going to be the only one on the deed. Now, I'm on the deed as a married man, right? So when in another segment, we'll talk about being married and being a seller. So in theory, your spouse may still have an interest, but her signature is not going to be required. And so that is a North Carolina specific law. And I will add, a lot of lenders who don't do a lot in North Carolina don't know about that law, and they may still require your spouse to sign. So in the end, your lender's still driving the train. It's their money, it's their lien, and they get the final say on whether your spouse is going to sign or not. It's not necessarily your choice.
Exactly, and a lot of lenders are very finicky, I guess is the best way to put it, and they're going to require your spouse to sign regardless of the fact that we can tell them, legally speaking, it's not required. So don't get angry with us if that's the case.
The other thing I would point out, you mentioned that there is an exception. So if you and your spouse can contractually agree as to when each other are required to sign. So in North Carolina, we have something called a free trader. A free trader agreement would allow you to operate kind of like you're single. Even though you're married, you can operate as a single man or a single woman. Signatures won't be required, but that's something an attorney's going to prepare for you. That has to be recorded, and everybody has to sign that. Both spouses have to sign that. A separation agreement or a prenuptial agreement can serve the same purpose. It needs to reference some statutes. The point here is that you can't just draft this on your own.
And we see that. We see people bring in a copy of something they've drawn up themselves, and that's not going to be sufficient. It's got to reference the proper statutes. If it's not already on record, we're going to have the original to be able to record it. So don't bring us a copy, don't email us a copy, because it's not going to work.
Yeah, separation agreements get pretty messy because they have things that you may not want. They may have things in there that you don't want to be a public record, right? When we record something at the Register of Deeds, it becomes a public record. So if you prepared your own separation agreement, you probably have maybe child care arrangements, some debt information, some asset information. You don't want that on public record. If you go to an attorney to prepare a separation agreement, they're going to prepare a separation agreement with all the nitty-gritty stuff that needs to be in there, and then they're going to have a
memorandum of separation.
Yeah, just a little short that gets the stuff on public record that needs to be on public record. So the warning here is we have a lot of people who do their own separation agreement because no one wants to pay an attorney if they don't have to. But that's probably going to be insufficient for what we need, and we see that several times a month where people have tried to do it themselves, which is admirable. But something like this, it's, you're going to find yourself unprepared, and if spouses aren't getting along, it's hard to get something done really quick if you hadn't prepared ahead of time. So that I would just throw that in there.
And you touched on it briefly, and again, we'll cover it more in depth when we talk about marital status when you're selling a property. But if you use this narrow exception and you take title and you're the only person, like you said, you're a married man, and you have to understand that without one of these agreements in place or something on record, your spouse is still going to be required to sign. Your spouse still has a marital interest at that point. So it doesn't completely extinguish that interest. It's still there. So just keep that in mind.
I would add, too, one more, kind of rambling here, but one more thing that we see a lot is when a spouse inherits property. So, let's say someone has passed away and left me the family farm, and I want to go to sell that. We'll run into people who believe that since they inherited the property, their spouse's signature is not required. And it 100% is, unless there's another exception here that helps us out. And so that comes up quite a bit where people are really militant. Now, that doesn't mean, your spouse is entitled to any money. That's not what we're here to talk about. We don't know what each spouse deserves money-wise. But there is an all encompassing marital interest that has to be extinguished, and that's what signing does.
So yeah, in summary, plan on your spouse attending if you're buying a property, unless it's cash, in which case you can really do whatever you'd like. And then again, we talked about the fact that there is the narrow exception, but if you're dealing with a lender, if you're getting a mortgage, it's important to remember that it's going to be case-by-case basis depending on who that lender is. And other than that, I think that pretty much covers it.
Well, I hope this was helpful. We'll see you next time.